I'm Ben Meiselas from the MeidasTouch Network. The United States Supreme Court just made a monumental ruling regarding voting rights that is very surprising, but pleasantly surprising for empowering the Voting Rights Act to do what it was always supposed to do by preventing serious systemic discrimination and racial gerrymandering. The case, Allen versus Milligan. It was decided on Thursday, June 8th of 2023, and in a 5-4 decision, the Supreme Court ruled that Alabama's racial gerrymandering scheme was a violation of Section 2 of the Voting Rights Act of 1965. This was a very, very, very important ruling. I will read for you now Section 2 of the Voting Rights Act, which this ruling was based on. And Section 2 of the Voting Rights Act prohibits voting practices or procedures that discriminate on the basis of race, color, or membership in one of the minority groups identified in Section 4F2 of the Act. And the issue in the state of Alabama is that the black population is approximately 36 to 37% of the overall population. However, in the gerrymandered district in Alabama, there was only one majority minority district out of Alabama's 7 total districts. So while the black population in Alabama was approximately 40%, only one congressional district was representative of the black population in Alabama, and it was specifically gerrymandered in a way to suppress the ability to have at least 2 of the congressional districts be represented by the black population there. The challenge was brought by a legislator in Alabama, as well as some civil rights group that challenged this racial gerrymandering by the Alabama government on the basis that it violated Section 2 of the Voting Rights Act. And again, in this 5-4 decision, the Supreme Court ruled that it was a racist gerrymandered map. It was a discriminatory map. And to give you a little bit of the procedural posture in this case was brought before a 3-judge panel in front of a district court panel that hears voting rights challenges. And this 3-judge panel ultimately ruled in a 200-plus page decision that the Alabama map was discriminatory leading up to the 2022 midterm elections. However, on February 7th of 2022, the Supreme Court halted the district court's injunction, which would have eliminated the discriminatory gerrymandering and would have required the redrawing of the map in Alabama from 1 congressional district to 2 congressional districts that would be representative of the black population in Alabama. So the Supreme Court stopped what the district court did and basically granted certiorari for oral arguments to be heard later on October 4th of 2022. But ultimately, the time frame by the Supreme Court in using what's called its shadow docket, which means that they didn't even have a full oral argument and they stayed and stopped the district court's ruling. What that meant was that the racist map was allowed to prevail during the midterm elections, thus allowing Republicans to have an additional seat that they wouldn't have had if the district court's decision, the 3-judge panel, was allowed to stand, and oral argument would be later held by the Supreme Court. Whereas here the Supreme Court stopped what the district court did. And we've seen that practice a lot with the Supreme Court using its shadow docket powers. And under this case called Purcell versus Gonzalez, which was decided in 2006, this Purcell versus Gonzalez line of cases basically says that the Supreme Court should not, or district courts and federal courts in general, should not disrupt existing maps that are very close to an election. So what Republican states have been doing using the Supreme Court Purcell versus Gonzalez, when they do their gerrymandering, they wait to implement the gerrymandering, the racist gerrymandering, right before an election. And then they argue, well, based on the Supreme Court case in Purcell versus Gonzalez, you can't disrupt our discriminatory maps until after an election takes place. Meanwhile, you have a situation where the Republicans then who engage in this discriminatory gerrymandering are able to win seats based on their discriminatory gerrymandered maps. And this line of case law also coincides with the eroding of the Voting Rights Act in general. And let me just explain here. As per usual, the economy was also a huge topic for the day. And why wouldn't it be? It's changing faster than ever and demanding we all adapt to keep up. In fact, a stunning survey revealed that over half of Americans making six figures now live paycheck to paycheck. Now, even though Goldman Sachs is saying that classic investments are headed nowhere for the rest of the year, other markets are rising to fill that gap, creating incredible opportunity among the chaos. Because even if conventional markets flatline this year, other assets don't have to do the same. That's why I'm so excited to introduce our next partner, Masterworks. I actually spent a lot of time digging into this, and according to a recent report by Citibank, the asset with the lowest correlation to the stock market of any major asset class was art. It turns out contemporary art pieces have outpaced the S&P 500's return for the last 26 years by 131%. Now, this market used to be hard to get into, but Masterworks is the platform that lets you invest in multi-million-dollar paintings without breaking the bank. Masterworks has built an impressive track record of 13 exits, all of them profitable. These numbers speak for themselves. Now, with those kind of results, Masterworks offerings have actually sold out in minutes before, so there is a wait list. But I reached out to them to give you all VIP access to their latest offerings for watching the MeidasTouch network. To skip the wait list, head over to masterworks.art/MeidasTouch. That's masterworks.art/MeidasTouch, or just click the link in the description of this episode below. That's masterworks.art/MeidasTouch, or just click the link in the description of this episode below. Now, back to the video. Because back in 2013, the United States Supreme Court really chipped away at the Voting Rights Act. And in a case called Shelby County versus Holder, decided in 2013, the Supreme Court held that it was unconstitutional to use a coverage formula in Section 4B of the Voting Rights Act to determine which jurisdictions are subject to the pre-clearance requirement of Section 5 of the Voting Rights Act. Let me explain what that means and why it is critical to the decision in Allen versus Milligan and how we even ended up here. So before the decision in the case that I just mentioned, in the Shelby case, there was a pre-clearance requirement whereby a gerrymandered map would have to go before a district court panel or the Department of Justice, which would have to pre-clear the map in the first instance, whether or not it was a racist or discriminatory map. So that's one of the ways that the Voting Rights Act of 1965 had this teeth built into it. But when the pre-clearance formula was struck down in 2013 in the Shelby case, which effectively shut down the pre-clearance requirement in general, what this meant is that states, usually Republican states, and were able to, almost always Republican states, would implement these racist, these discriminatory maps. And because there was no pre-clearance, then what would happen is these civil rights groups would then have to challenge it. It changed the burden, and now civil rights groups would have to affirmatively sue to challenge a racist and discriminatory gerrymandered map. They would have to get an injunction from a 3-judge panel. And then after that was decided, then if it was the gerrymandered map was overturned, the Republicans would just say, oh, Purcell principle, we are now very close to the date of an election, so the discriminatory map has to be in place. And that's exactly what happened in the case of Allen versus Milligan. The Alabama legislature passed the discriminatory map. It was signed into law by the government. There was no pre-clearance. There had to be lawsuits brought against the legislature for implementing this racist, this discriminatory map. It went in front of the district court. The district court struck down the discriminatory map and said there should be 2 districts that are representative of the black population in Alabama. Then the legislature appealed to the Supreme Court. The Supreme Court said, under the Purcell principle, we're so close to the election, we're not going to allow the district court to disrupt what the legislature did. We're going to have to decide that on a more regular schedule where we grant certiorari, and there's oral arguments that are held later. So then in 2023, on June 8th, when the Supreme Court says, you know what? The district court was right 2 years ago when they made that ruling. They did everything right. This was a discriminatory map. Guess what? You now have a situation where Republicans now won seats in the midterm elections based on illegal maps that shouldn't exist in the first place. And not only did the Supreme Court's decision on the shadow docket to ultimately stay the district court's ruling, which struck down the unlawful map, impact what took place in Alabama, it also impacted what took place in other states like Louisiana, where there were discriminatory maps as well. And those cases were stayed. So like in Louisiana, exact same situation that kind of happened in Alabama. And we had to wait until this ruling and Louisiana's discriminatory map was allowed to stay in place as well. The ultimate challenge that was being brought by the legislatures that wanted to promulgate these discriminatory maps, though, was that Section 2 of the Voting Rights Act, which I stated at the outset. Essentially, they argued that is unconstitutional under the 15th Amendment, and that there needs to be race neutrality, race neutral tests with respect to the 15th Amendment, with respect to the Equal Rights Clause. And what they mean by that is that specific laws that have been implemented, this is the argument of the state legislatures that want to put forward these discriminatory maps. What they're arguing is that these laws that have been created to promote voting rights and to ensure that there is no discrimination, or we try to eliminate discrimination against black voters, that those laws are inherently racist because they focus on race in the first instance. Well, they focus on race because they're trying to remedy systemic racism that existed and it still exists in our country. That is why you had the Voting Rights Act passed in the first place of 1965. So the challenge being brought by the Republican states and the state of Alabama here in trying to keep the discriminatory map is that Section 2 should essentially be eliminated. So because in 2013, Section 4 was viewed as unconstitutional, which effectively eliminated Section 5, the preclearance requirement, now Republicans were going after Section 2, and basically that would have meant the Voting Rights Act would be destroyed in general, and all of these discriminatory maps were allowed to stay in place until the Supreme Court just issued its ruling in the Allen versus Milligan case on Thursday, June 8th. So now what we're seeing, for example, the Cook Political Report has now said that at least 5 congressional districts that were solid Republican or toss-ups are now either toss-ups or lean Democratic. So what this could mean is that there is a potential for Democrats to pick up 5 seats in Alabama, Louisiana, and North Carolina as a result of this ruling. What this also means is that the majority that exists in the House of Representatives right now for the MAGA Republicans, and with all of the absurd hearings that they're holding and all of the ridiculousness that's taking place, where they have this very slim majority, had the district court case been allowed to remain the law of the land, had the Alabama district court case been implemented and the Supreme Court not issued its shadow docket ruling before the midterm elections, it would have meant that the Democrats would likely have maintained their majority in the House of Representatives with this 5-seat pickup in the House of Representatives. But nonetheless, what is important, and I'll just read you the judges: Ketanji Brown Jackson, appointed by Biden; Justice Sotomayor, appointed as well by Obama; Justice Kagan, appointed by Obama; and then you have Roberts and Kavanaugh. Roberts was appointed by George W. Bush. Justice Kavanaugh was appointed by Donald Trump. Those 5 were in the majority. It was a 5-4 decision. Clarence Thomas gave like a 50-page dissent where he basically, in essence, called for the abolition of the 15th Amendment and said the abolition of the Voting Rights Act in general. But this 5-4 decision, though, now means that with respect to a lot of this discriminatory gerrymandering, which tried to exclude majority-minority districts, that those will now be struck down, and we will have a situation where you have a lot more Democratic seats, because that is actually reflective of what the population is in these states, right? It's not arbitrary. It's that Republicans have engaged in discriminatory and racist gerrymandering to try to create a situation where the state populations were not reflective of the gerrymandered districts. And now I think we're going to see this is going to be hugely important in 2024. So I know all of that may be a little bit complicated, but it was important to understand not just this ruling as it relates to Section 2 of the Voting Rights Act and protecting and preserving that, because that's ultimately what the Supreme Court ruling did. So the Alabama state view of the Voting Rights Act is complete BS and garbage, and that the Alabama gerrymandering was indeed discriminatory, and Section 2 of the Voting Rights Act survived. But we also have to understand how we got here in the first place with the Purcell principle, going back to that case from 2006, as well as the Shelby decision from 2013, which removed the preclearance requirement from the Voting Rights Act, which is what's allowed the Purcell principle to be used as a tool by Republicans to say, hey, our discriminatory districts should not be touched until we get past an election, and then they push in their Republican candidates. I'm Ben Meiselas from the MeidasTouch Network. Big, important ruling. Hit subscribe. We're on our way to 1.5 million subscribers. Check us out as well. Patreon.com/MeidasTouch. Wherever you get audio podcasts, make sure you subscribe. Have a great day.
Hey Midas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.